right. Start webinar. Hi, everybody. Welcome in. We are live once again. Thank you for coming in. We still have 2 minutes, a minute or two to settle in to start our webinar. I'm going to briefly share my screen and also share with you what we're going to talk about. I'm very excited to talk about this topic with our guest speaker today, immigration attorney Trinity Xu. I think you're from Chicago, right? You're located in Chicago. We did a previous session before in Haas conference where we break down the nitty-gritty of NIW. I think a lot of people were interested but didn't get enough time to ask questions. So we wanted to host this session in a broader array. We want to include O1 visa as well because last time I think O1 was also one of the interested topics that people are trying to figure out. So today we're going to speak on O1, NIW, Day 1 CPT, all of that good stuff. So if you are, following close attention to H1B, if unfortunately you haven't get selected by H1B, there's still chances, by the way, for this year. So we never know. But if you're looking for an alternative plan, definitely tune in to today's session, ask questions live if you could. And then I think we're on time. I'm getting ready to lunch. I will briefly introduce today's topics and today's speaker. So I'm very excited again to welcome back Trinity Xu, immigration attorney from also the founder of Pathora Law Firm. And then Trinity today is going to share with us some of the details in terms of O1, NIW, and CPT. So we're going to talk about F1 to a specific green card. What are some of the details you might need to know? For example, priority dates, visa bulletin, self-petitions, and stuff like that. And then if your H1B hasn't got picked yet, is Day 1 CPT a good option? If you're not considering Day 1 CPT, is O1 or self-petition green card feasible to you? So if you have a question, I don't know if you guys have all attended this webinar like this before, but if you have a questions, send them into the Q&A sections right now or later on. And our teammates, we're going to collect all of the questions and we will answer them one by one for you at this second half of today's webinar. Before we jump in, I want to briefly introduce who we are as the host. We're Go Elite. Our primary service is we do education consulting services. So we work with Day 1 CPT universities. We consult those students in terms of their Day 1 CPT decisions. We are certified by AIRC as one of the most respectful organizations in the U.S. educational space. And here are some of the exciting campaigns we're bringing out to our students. We started a Day 1 CPT community. Once you join the community, you can complete activities to earn points, and then that could translate into rewards that you can claim. So feel free to check them out. We included that into today's session's reward resource tab as well. And then we also started a forum for you guys to, again, chat and talk in the community. So definitely the link will be included. Definitely feel free to check out. We're on Google reviews. Feel free to check us out on Google. We currently have more than 500 five-star reviews. And then we're also on all of the social media channels. So feel free to check out our content, give us a follow. And then without further ado, I will stop sharing my screen. So Trinity, you can share your side of the screen and introduce yourself.
Okay, wait a second. Let me try to pull up the slides. Okay, hello everyone, and good afternoon and good evening, whatever time zone you're in. So today we're going to navigating the system that could be overwhelming for all of you because probably the reason why you're here today is because your H1B doesn't get selected and you wanted to find some alternative to sustain your legal status here in the United States that allows you to probably work or at least to stay here in the United States to look for more opportunities. But here raise the questions like, which path is the right path for you? Because there are a lot of different options. Some people suggest that you can transfer to a B1, B2 visa to just trying to land on a job before your status expire. And some people say you can probably go for O1 or you can probably go for a national interest waiver. And different type of visa has different criteria, and they're all very different, but sometimes their criteria can overlap with each other a little bit. So today we're going to navigate a little bit more on O1 and national interest waiver, and we're going to wrap up with a final resort, which is the CPT option as well. So let's just go to the pages. Okay. So why we need to consider alternative to H1B. The first is, let's look at this fresh data just published yesterday, I guess. So when you see the fiscal year of 2026, you can see that this year, the selective registration is a little bit less than last year, but actually the percentage people get selected went up. So it's around 35% this year. You have 35% of chance to get selected for fiscal year 2026. But this is because of several reasons behind it. The first, the price of per lottery raised from $10 to $215. That's the first reason. And the second reason is because they put a higher scrutinies on, they don't allow people to put into two lottery for a person this year anymore. And the system has a better detection system. And so those people who were registered for twice or even more, they're not considered anymore. But even though the chance is higher this year, H1B still come with some limitations. Like, for example, if you're only be able to work for the petitioner that petition for your H1B. So no matter that you have one job or multiple jobs, each of your employers will need to do this petition for you. And if you have multiple petitions, your working hour cannot be more than 40 or 50 hours a week, because that's going to raise concern and increase the chance of you getting an RFE. So in this term, you don't get work mobility as much as a green card holder or even a citizen. And the other thing is H1B requires an employer sponsorship. So it really depends on the market and if your employer is doing well or not, and if they're willing to do this petition for you. So it still has a lot of limitation. And the last point is H1B is never a final step for people if you wanted to stay in the United States for long term, because it's just a work visa. So at the end, you will still need your employer, or you'll still need some other ways to get your green card. And usually the most usual route for people to get a green card is through the PERM process. And a PERM labor certification process will take 3 to 5 years. And not to mention, a lot of big tech company, they probably will have advertising procedure, but those advertising procedure fails all the time because they can actually find those qualified US citizen worker to satisfy those job requirements. So this is the reason why we're going to look for other options that help people. If you have the ability to petition yourself, or you have the ability to satisfy for other criteria, you can probably look for some other options here. Okay. The first one, we're going to look at EB2 national interest waiver. And it's a green card option. So it's not like a work permit or work visa that guarantee you to work right away, because there is a long period of wait time on this category right now. So for people in general, that's going to take around 1.5 years right now. After you submit your petition and your petition is approved, you still need to wait for 1.5 years to get your green card. And for Indian nationals and Chinese national, it may take even longer. But a good side of EB2 national interest waiver is that if you're, you get to set a earlier party date, and it doesn't need any sponsorship from your employer. So let's look into this criteria a little bit more. National interest waiver, basically, you will need to gather 3 puzzles to make your case work. The first puzzle is you will need to propose a future endeavor. And this endeavor is not like just a random job duties or a random job occupation that you just tell the immigration officer, I want to be a software engineer in the future. And being a software engineer can benefit the technology advancements in the United States. That's not enough. You need to elaborate on what's your future undertakings, what's your future plans for this nations, and how is your future plan can benefit this nations and provide some substantial merit to the country. That's the first puzzle. And the second puzzle is you will need to elaborate on why your previous work allows you and enables you to carry out your future endeavor. That means, so for example, if I'm an attorney and I told immigration officer that I would like to do some AI development in the future. That's not going to work because I don't have a successful track record in the AI areas that support me to carry out my future endeavor. So the future endeavor and the previous work, these two puzzle will need to be connected very well. And the third puzzle is like sometimes people usually forget this part. You will need to just demonstrate to the officer that you are not only have a good plan and you have a good background, but you also have people line up and waiting for you to carry out your plan already. So for example, for people who is still outside of the States, you cannot simply saying that the reason why I want to get a national interest waiver is because I had good plans and I have good backgrounds but I just still need to get a job in the United States. The immigration officer is not going to buy in such statement. They want you to already have a job position waiting for you, potential clients line up. And probably even better, sometimes if your plan or if your patterns, if your endeavor are supported by US government initiatives, like you're receiving fundings, that's even better to show you already have the potential interest, not just from some entities in the United States, but from the US government itself. So after we look for those three puzzles, let's look at some eligibility here. So basically, I believe that most of the people attend this meeting today will fit into the eligibility. So the first is you have a bachelor degree and you have 5 years of work experience. That will qualify you to apply for a national interest waiver. So after you satisfy the eligibility, immigration officer will start to read and review your qualification for that. And the other eligibility probably people here will just satisfy as well is the advanced degree. So as long as you have a master's degree or higher, like PhD degree or MD degree, you're eligible to apply for a national interest waiver. And I want to mention some very important points here. So let's say a lot of people come to the United States with different bachelor backgrounds. So for example, people probably study civil engineering in the past, but they come here, they wanted to do some computer science related work. They want to do some other things that is not within the civil engineering field. And that usually will solicit higher chance of receiving RFE because your advanced degree doesn't really match what you're going to do in the future. So you cannot just argue that I have an advanced degree, but in some other areas, but that also qualify me to apply for a national interest waiver. Sometimes the immigration officer will just apply for higher scrutiny on these type of cases. And the second part, after you are eligible, immigration officer is going to look for 3 prompts. These 3 prompts are just a puzzle that we're talking about, but we just illustrated in a more easy way for people to understand. So the first prompt is you need to demonstrate your future endeavor carried a substantial merit, means that it actually can benefit the United States and not just like benefit a specific employer or benefit a specific client base. And the second part is national importance. It means that your project or your future work has the national scale of importance, not just benefit, let's say, your clients and not just having a very tiny bitty influence to this country. And the second prompt is you need to demonstrate based on your degree, based on the certificate you received, based on your previous successful track record, you are well positioned to advance this future endeavor. And the third prompt is the last prompt. So we recently have seen a lot of requests for evidence coming from prompt 3, is that you will need to demonstrate the US will benefit from removing the PERM requirements for your case. Because I saw a lot of petitions that argue there is a shortage in, let's say, there's a shortage in data scientists, there's a shortage in software engineer, so we need this person right away. But if you use these arguments in prompt 3, immigration officer will raise a concern here. If you wanted to prove a labor shortage, then you should go through the PERM process instead of just telling me that there's a labor shortage and you cannot find qualified worker. So prompt 3, you will need to focus on why your expertise is so special and so urgently needed for the US. Let's say you have a pattern that US so far is not, we haven't seen this pattern being used in the US so far. And probably you develop a system, you develop a technology, a methodology that can benefit the businesses in the US. So that's the probable ways to demonstrate that this country will benefit from removing the PERM requirements for your case. And what is the advantage that we're doing national interest waiver here? Because it still have a wait time, right? So the benefits of the national interest waiver here is that it has a lower eligibility requirements for the application. So let's say for people who's like still wanted to apply for EB1A or wanted to apply for a different category in the future, you can set a earlier priority date, and it's a lower criteria than EB1A and other category. And the second one is earlier priority date is always important because a lot of people still want to come to the US, and the immigration wait line is going to be long. Even the EB5 or other category, the wait line is getting longer and longer. So national interest waiver, lower bar, and easier to apply. That's the reason why I see a lot of national interest waiver petition recently. Yeah. Okay. And we're also going to talk about some policy change that this year freshly established this year. The first is that because in the past, immigration officer use a case to discuss the criteria for EB2 national interest waiver. It is not like EB1A that listed 10 criteria and tell you like, if you only satisfy for 3, you can pass the EB1A. So national interest waiver is a little bit more vague. It doesn't provide as much as detailed descriptions, just like EB1A, what are they looking for? But this time they kind of just elaborate what type of materials they're looking for. So for PROM 1, how to demonstrate that your work has national importance. You can probably get some executive order from the White House showing that the current administration is focused on the technology development, the areas that you're focused on. So for example, when the new president administration take off their office, people started to get worried about, oh, this president is trying to revoke all the executive orders of the past of Biden. But the thing is, this president still care about the artificial intelligence. He still care about manufacturing. He still care about the technology development in the United States. So it's not like if we change the precedents, everything will be different. There is still some somehow difference in different type of cases, but for people who has an advanced degree in STEM, I think the new precedent doesn't really impact the case that badly. So some cases are still workable. And you can also look into some National Science Technology Council, what's their initiative and what's their funding going through to demonstrate that your work is on a pillar, what this country cares about. And PROM 2 is more about your backgrounds, your criteria, how you can carry out your plan. So PROM 2, I will be very honest, this time the policy change really favor PhD people because PhD usually have publication, they usually have those open source or scalable methodology and research findings for different companies. So that's the first thing. If you have a PhD and you have some citations and you have some publication, you should probably go for a national interest waiver as soon as possible because that will get you land on an earlier priority date. And the second part is immigration officer very specifically saying that the degree itself alone doesn't support a full PROM 2. So you cannot just argue that because you got a degree, because you got your certificate, and that qualify you to do your future endeavor. What they're looking for is, I listed here, what they're looking for is something like publications, and your publication has citations from some prominent organization, from some researchers, or you have some peer review experience reviewing journal. And sometimes my client asks me one question. If you conduct interview on other people, let's say if you're a senior member in your company, you consistently review those internships work and you interview people, does that count? I would say that it generally doesn't count because it will limit your experience to just benefit a company again. But judging and review experience can show that your expertise and your contribution is benefit the whole industry or the areas of your research. And the next one is, I think this one is probably easier for people. So you will need to get letter of recommendations from expert in your area. And this expert should be independent. What does it mean, independent here? It means that this person never collaborated with you in the past, and this person is not like your mentor, not like your teacher in schools. And also this person cannot serve as your mentor when you're during your internship, because that just like showing you have your personal connection with this person. And the other evidence that can be helpful is your patents. And for EB2 national interest waiver, the patent doesn't need to be already patented. It means that it doesn't need to be certified. It doesn't need to be 100% fully granted patents, but you can just be published, and it shows that this patent is already bringing profits and already being used in a commercial practice. And the last one is funding. But I guess funding is more like for PhD students or for postdoc people who's like working in some laboratory or working in some research environment. So people who has industry background usually doesn't have the funding here. Yeah. And next one, we're going to touch a little bit about O1A. So O1A is also a route for entrepreneur, for people with the STEM background. And its criteria is very, very similar to EB1A. So a lot of people will consider O1A as a first step before you actually land on your EB1A. And let's look at these criteria. So O1A has 8 criteria, and you must satisfy some of these criteria to get selected. The first one is you win an award or a prize. Like if you win a Nobel Prize, you probably is not just going to guarantee for O1A, you're probably going to be guaranteed for EB1A as well. And they also look for membership. And the membership here, it's not just like a pay to join membership. Let's say a lot of different associations, they probably will provide you with a chance to just pay a fee to subscribe with their emails or subscribe with their inside informations. But any membership that's only going to be paid to join, like Costco, that's not going to be helpful. It needs to be with some selection criteria. Let's say you need to prove that you have certain years of work experience, and you must be nominated by some peers in your fields or by some other members in the association that demonstrate that you actually has the ability and the quality to qualify as a member. And the third criteria is like if you have a published materials about you and your work. So this is an interesting topic because a lot of people come to me and they ask me, my work is published by my companies on their website, on their blog. Does that count as the published materials about me? But usually if you're only let's say a senior person, but not with a managerial title or not a director or not a C-suite level people, they usually don't put your names on the articles. And that can merely be your work samples, but it cannot be called as a published materials about you and your work. So a lot of firms or a lot of media outlet do provide some background enhancement plan that if you wanted to have some published material, but it really depends on how you wanted to build your case. So I would say that published material is usually not very common that appear in this, like people don't usually satisfy this criteria. And the next one is judging experience. Judging experience, sometimes people will feel like, oh, I need to be a PhD, I need to be a doctor, I need to be a postdoc to be invited to review those journals. But the thing is, those journals right now really are in need of people to review those articles for them. So if you have certain years of work experience, they sometimes will just allows you and invite you to be one of their reviewer. And the other judging experience and review experience you can get is probably trying to participate in some hackathon or trying to participate in some other petition, and that could help too. And the next one will be original contribution. Original contribution sometimes is a little bit vague and it's a little bit hard to satisfy because you need to demonstrate that your contribution is original. It's not like just very similar to what it has already exist in the field. So what they're looking for here is published articles, or you have a patents that demonstrate that because you're granted a patent. So this must be very original, that the USPTO already granted you a patents or some other evidence showing that your contribution is not merely a methodology that being applied to different organizations and you just make a slightly customization to it. And the sixth criteria here is about the authorship. And authorship is about publication again. So you will need to show that you are a first author, second author in these publications, and why you are a key person in this publication. And the next one is your leading role. And leading role and high salaries are usually bundled up together. Leading role doesn't necessarily mean that you have to be a leading role in an organization. Let's imagine if that was a big tech company, a big organization, it's really hard to be a director, or it's really hard to be like a C-suite level person. But as long as you can show your leading role in the project or in the contribution you made, you can claim a leading role as well. Yeah. So, and what's the advantage here for the O1A visa? It's because it has much lower requirements compared to EB1A. So for example, EB1A, probably you will need to, if you wanted to claim high salary, you need to earn more than 90% of your peer in your field. And O1A can be lower than that. And another advantage of O1A is because it can be a backup option to H1B. If you don't get selected for H1B, and if your employer is still willing to work with you, and you happen to satisfy all some of these criteria, you can ask your employer to sponsor your O1A. And O1A is not like your employer needs to demonstrate that they have the ability to pay your salary, but more like you need to demonstrate that you have the ability to satisfy this criteria, individual with the extraordinary ability in the STEM. But I wanted to emphasize here, O1A is just a visa, so it's not a green card qualification. And if you wanted to ultimately stay in the US, you will still need a green card. But you can consider O1A as a first step before you go for EB1A, because that was actually indeed the same criteria, but just like the bar is different there. Yeah. And the next one, I have this chart here for everyone's about the comparison between EB2 national interest waiver and O1A and O1B here. So let's just get a summed up here. EB2 national interest waiver is a green card, but O1B is just a visa. And the thing is, EB2 will has the standard for the 3-prong test, and it's more flexible, a little bit more flexible than O1A and a little bit more flexible than EB1A. And EB2, because that was a green card petition, so it can secure a earlier priority date for you. And if your H1B is going to be maxed out in the future, you can use approve I-140 to extend your H1B. And that also get your spouse H4 EAD that allow the person to work. Okay. And the next one, I also wanted to touch on the topic of the green card priority date and visa bulletin a little bit. So what is the relationship between I-140 and I-485? So I-140 is for EB2, EB3, EB1A. You will need to fill out this form. And after this form is approved, you need to wait for the priority date to be current as a visa bulletin. Then the next step will be apply for green card. And if you happen to be in the US, you have a valid status in the US, you can apply for I-485. But if you're out of status and you cannot stay in the United States to wait for your visa bulletin to become current, you'll need to go back to a foreign country to do a consular processing, to do your green card interview there in another country. Yeah. And there is a question here that I usually got asked. Will using a premium processing for I-140 expedite the priority date? No, the answer is not. So paying more money doesn't get you an earlier priority date. The priority date for a national interest waiver will be the date your package arrived in the facility. And of course, if your case got approved. And for PERM, that was the day you submit your ETA, submit your PERM. So the priority date will never change because you spend more money here. And the next one, I would also wanted to touch a little bit about a chart 8 and chart B. So people are always wondering which chart should I look at about this month. You will need to read this every month, because every month the current month adjustment of status filing charts, the immigration officer will publish a different instructions on this. So for example, for May 2025, they are using the final action dates. What is the final action date? The final action dates means they are looking for chart A, not chart B. So, and the dates listed on chart A and chart B is quite different. So the first step is always to check what is the current month adjustment of status filing charts? What are they looking for before you actually file your case? Because if you file your case before you can actually file it, immigration officer won't accept your case. Okay. And next, we're going to touch a little bit about a day one CPT. What is the point of getting day one CPT if I have a lot of options out there? Because day one CPT actually allows you to have a lot of flexibility while you're waiting for a visa bulletin to be current, while you're out of status, while you doesn't get selected for H1B. It offers a lot of perks and a lot of benefits to change your status to CPT. Okay, so let's talk about this. So what is day one CPT? Day one CPT is a curricular practical training program that allowed F1 students to begin work right away after they're enrolled with the school. So why is this so important? Because it allows people who didn't get selected and probably your criteria doesn't satisfy in O1A, day one CPT will be a good option. And I also heard that some people are talking about, oh, if I get laid off during my H1B, if I am out of status after my H1B doesn't get selected and I'm still on F1, and I should transfer my status to B1, B2, which is the tourist visa. And but I always suggest people to land on other category of visa instead of B1, B2, because if your ultimate goal is still trying to stay in the United States, and if you're just trying to use this visa status to land on different jobs in the future, when you click on those linking apply message, they will ask you, do you have a valid status here to work right away? But if you're on your B1, B2, you cannot work, and you will need to transfer to other status that allow you to work. That is why day one CPT allow some flexibility here. If you're currently on day one CPT, you don't need to work, but you can still like finishing schools and trying to land on a job when you're still completing school. And you can click on the button, like you are able to work right away compared to those people who are just still on their B2 visa. They cannot work right away, and transferring from B1, B2 to CPT still take a lot of time because you will need to prepare documentation, and not every schools will have enrollment for you every day. Every school has their specific enrollment dates and timeline. They process those applications for your F1 visa status. So that's the reason why you always have to just know what your worst scenarios will be and check the programs you can enroll into to ensure that whenever you are out of status, you can still have a valid status to stay here and to work here if to stay here is your ultimate goal here. And day one CPT could also be considered when you are waiting for your I-140 approval. So for example, some people probably they're still under their F1 OPT, but they apply for I-140 and they got approved. However, they didn't get selected for H1B because sometimes that luck happened. And if you have an approved I-140, you can still have the chance to apply for a CPT. But the trick questions here is we usually suggest people, if you already have a pending or if you already have an approved I-140, just change your status in the United States and never trying to do a consular processing for that. Because if you go back to your home country, or if you just go to Canada or you go to Mexico, you could have a chance that the CBP officer or the people who do your interview, they're trying to questions like, how can you demonstrate that you don't have any immigration intentions and you still want to go back to your home country when you already have an I-140 approval? And that could create complexity. So in all honesty, just do your CPT, change of status here in the United States. And we still see a lot of successful cases while people have a pending, while people have an approved I-140, and they can still get on a CPT. Yeah. And the next one is I already touched on this topic in the previous slides. So if you have an I-140 approval, it still can slightly affect your CPT approval because you will need to demonstrate that why now you wanted to apply for another F1 student visa. And usually a legit CPT school will provide you with a document list, what type of documents you will need to submit to make sure that an immigration officer understand why you want to transfer why you need to change your status to F1 students. You will need a better personal statement to demonstrate that probably in your work and during your experience here in the United States, and you discover that you have some deficiency on your knowledge and you wanted to use CPT as a way to give you a boost and give you some supplements on the knowledge that you still need for your work. And that usually gets your CPT approved without any questions. But if you receive an RFE, like request for evidence for your CPT status, the good schools or good agents like Go Elite, they usually prepare a package for you to respond to those RFE. So you just need to check those, like finish all those documents and finish all the list on whatever documents they are requesting for you. Your CPT should be no issue, even within approved I-140.
I wanna ask a clarified question for you, Trinity. I think a lot of us listening will be curious in the situation that you just mentioned, for somebody that are in the middle of a green card application and wanted to transition into day one CPT. Were you specifically referring to those who come from a different status and they wanted to transfer to F1 status, and that might have trouble, that might run into some kind of RFE when they wanted to change status to F1 because they wanted to do day one CPT now. Because if they were F1 students all the way, if they were OPT students, now they are CPT students, there is no immigration application involved. It would just be transfer CVIS from one school to another school.
Yeah, so if you're just originally on F1, you're on an non-immigrant visa and now you're transferring to another school, that will have no issues. But the only issues here will be you will need to choose a school that you can attend because CPT will require you to have you will need to attend school every quarters, every month. And if you contact Go Elite, Go Elite usually suggests schools that is close to your apartment, close to where you're located, and they will suggest you to school that actually match your background. So for example, if people already get a degree in a specific area and they're getting another degree or in another degree, multiple degree, more triple degrees on one single area, that could raise some concern for USCIS because they will question why you need so many degrees and they're all centered in one same topic. So usually when you go to the legit school, they will let you know what type of schools and what type of study that suits you better. Yeah.
Absolutely. Thank you so much. We can continue.
Okay. And so the common concerns for CPT program is, just like I said, you will need to choose a reputable. There is some red flag institution that if you don't go through the agents, you just wanted to do the research yourself. You wanted to find the cheapest options. You want to find the options that are probably the closest to you. But sometimes you're setting yourself into an abyss that you cannot turn around. So just make sure that you're attending the good schools. The school doesn't have any red flag, and a school is close enough to you, and a subject you choose is aligned with your background, and you will have no issues with CPT. Yeah. Okay. So I think I basically covered this risk part as well. Yeah. And I think we can go to the Q&A section.
Sure. I'm just gonna pause a little bit for everybody who want to scan the QR code. I also attached Trinity's email of her law firm, so if you wanted to get in touch with her to consult or proceed with the application for NIW or O1 visa, she can definitely help you with that. And without further ado, we do have a lot of Q&A session already waiting for us. So I'm gonna share my screen for now, and then we're gonna jump right into the question session. So meanwhile, if you guys have new questions along the way, feel free to send them into the Q&A section, and we will collect them in here as well. So the first questions, I know this might not be relevant to NIW or O1 at all, but one option that people are also looking for is oh, I thought this was a cap exempt H1B, but this person is talking specifically about a cap gap between OPT to H1B. So you got me confused just a little bit, but I think we are on track right now. So could you explain a little bit about the cap gap? Basically, if somebody got selected by H1B, I assume that's what they mean, and then they will have a cap gap for them to continue their OPT until their H1B become effective.
So if you're, so for example, let's say people usually start their OPT around June or July, but H1B will start activated in October 1st because that was like everyone will start on the same date. And the cap gap means the period of time between your OPT status expires and before your H1B can be activated. And during that time, if you wanted to just still maintain a valid status, you will need to just file your H1B case and then file for a cap extensions. And in that scenario, you will need to choose, you want to change your status here in the United States. If you choose the options that you want to go back to your home country, you want to go through a consular processing, you cannot get a cap extension. Cap extensions only applicable for people who wanted to change their status in the United States, because that's a benefit the immigration officer offered to people who just wanted to stay here and keep their working status valid to work for their employer. Yeah.
Absolutely. And I think there was also a good news regarding CapGap that just launched this year. It was last year, it was that OPT student can extend their OPT until August 1st. And I think the US government further extend that timeline so they can actually have the CapGap until next year. But for anybody, I don't have a specific date for you, but for anybody that are interested in CapGap, you can quickly do a research and they will have a specific timeline for you. Let's move on to the next one. Does letter of intent also work for EB1A? Does work experience for your home country count for EB1A?
So the letter, I think different firms and different people will have different ways to refer to different type of letters. Like, for example, when I was looking at this letter of intent, I'm thinking, is that probably like a letter to show the US has potential interest to your work? Yeah. So EB1A will also require these type of letter, because basically you're still going to demonstrate that your work is still going to benefit this country. Not just you are a good person, but you are not going to work whenever you get your green card here in the United States. That's the first thing. And the second question is, does work experience of your home country counts for EB1A? Yeah, it does count. For EB1A and EB2 both counts. Yeah.
I want to make sure that if you could still see my screen, I think something happened. I wanted to try to restore the sharing.
Okay.
Just give me 1 second. Okay, now I think now we're back. Can you see my screen now?
Oh yeah, I can see the screen.
Okay. Let's move on to the third question. When do you start to apply for that visa? I don't know which visa are you specifically referring to, but let's just say if it is O1. When do you start to apply for O1 if you're an F1 visa holder for now?
I would say that you will need to check with your employer and check with your attorney how long usually take them to prepare a package for you. And O1 also have a premium process. So if you wanted to apply for premium processing, you will get your results within 15 business day. And you will just need to calculate days very carefully to make sure that you can still be working. Because if you lose your status on F1 and you have a pending O1B, the thing is you can stay in the US because you have a pending O1B petition. But if you just have a pending O1B petition, but you don't have any other valid status, you cannot work. So you can just stay here and wait for your results, but not working. And most of the employer hate those gaps. They don't want you to stop working for them. So just make sure that you realize the timeline and make sure that you gather all your documents in time. Yeah.
Yeah, that's the same thing. Actually, that's the same thing with Day One CPT as well. A lot of students that will consult us we will always say if your OPT is ending, you're gonna aim for a start date of a particular school that starts a little bit before your OPT end. Because if your OPT ends this month, for example, but you find out a program that is gonna start in next month or even after, you're gonna wait for that 1 month or 2 months to be able to have legal authority to work, and then your employers might not like that. So definitely plan ahead for these kind of things for O1 and for day one CPT. I think it works universally. Let's move on. Next one. What would be our visa if we decided to do an EB2 NIW? I guess this is asking from the background of what visa could we use while we're waiting for NIW. And then this person also have some information regarding I have 1 year worker authorization remaining for stand OPT. If my company decide to apply for EB2 NIW, then can I do day one CPT? How much time would it take for me to stay in day one CPT? I think maybe I can answer the day one CPT part just to be clarified a little bit. So there isn't really a cap of how many years of CPT you could take. So technically, there is no regulation saying that you could only use CPT for one time during your master degree. So there is no rules regarding that. We see people use master CPT for one time, two time, or even three times. They went through different degrees to just be able to maintain their student status. But normal practice, we also see people who had their US master, who had a day one CPT master, and then went up for doctoral day one CPT program, and then you can continue. That might buy them probably 3 to 5 years or even longer. It would depending on your particular case for sure. So if you do have a question regarding how can you proceed with day one CPT, we recommend you to scan the code, talk to our consultants. We can provide a better plan for you. But regarding the first part of the question, what kind of visa can people rely on if they wanted to stay on the wait for NIW? And then also if somebody's stand OPT is ending, how long could that be for the person to actually get that NIW?
So that's actually a very big question. So there is a lot of different visa you can consider. Just like CPT will be an options and H1B will be an option, but H1B you will need to get selected. And O1A could be options, but you will need to satisfy all those criteria. And the worst scenario is just if your employer doesn't accept you work under CPT. That's the first scenarios. And I will suggest that you can consult Go Elite, and they will let you know what type of negotiations you can try to negotiate with your employer to let them accept the fact that CPT is a legit program and you can use CPT to work when you are waiting for your green card to get approved. That's the first options. And some company may allow you to work in their other, like for example, let's say Meta has a branch in Canada and they kind of just make a lot of some of their employees to work in Canada for a while and let them come back to the United States with their L1 visa. And I see a lot of tech companies do that because that allow them to have some flexibility because L1 is also a dual intent visa, just like H visa. And after you use your L1 visa to come into the United States, you can either go for EB2 national interest waiver or just go through the same PERM process. And that could be the second scenario. And the third scenario is just if your company just probably they want you to work as a foreign contractor and they're happy with that, you can always do your EB2 national interest waiver. And after your case got approved, you just wait in your home country and whenever the visa bulletin is current, and you just go to the consulate and do your green card interview and get your green card and come back to the United States. That could be an option too. Yeah.
Absolutely. Thank you for that detailed explanation. Let's move on. For those who might have joined late, people might wonder, can you explain like in a brief turn, what are the qualifications for NIW? I know this is a huge subject. There's just lots of details, but if somebody who never knew about NIW, who wanted to get their first hand of information, how can you tell from simple terms if they're qualified or not?
Okay, so let's go through the ABC test. The first one, you need to be eligible to apply for a national interest waiver. These part, we are not even talking about the qualification, but we're just talking about if you're eligible to apply for a national interest waiver. If you're not eligible, your case would just get rejected right away. So a few options. You can be with an advanced degree or a bachelor degree with 5 years of work experience that could qualify, that can make you eligible to apply for a national interest waiver. And after you satisfy this eligibility, then we move on to that qualification. You need to demonstrate to the officer that your future proposal, your future plans, the things you're going to undertake in the future has substantial merit to the United States. And this substantial merit also is of a national importance level to this country. So which means it's not only going to benefit a specific employer or your clients, and because that's like a larger scale of your importance. So that's the reason why they're guarantee or like they're not requiring you to do the whole PERM process. And the third part, you need to demonstrate that even though there are some other qualified US workers, and even though they could be some other options there, but granting you this national interest waiver, waive your PERM process, is still going to benefit to this country because it has a urgency, because it has some fundamental reason why they want to waive this for you. So that was like the three puzzle you will need together.
All right, absolutely. Next one, I think a very good question. So we talk about PhD being a huge factor in NIW. So does the PhD degree has to be inside of the US? Does the person have to attain that degree in the US?
No, PhD in any country works. And the thing is, if you obtain your degree in a foreign country, you will need to evaluate your degree because immigration officer doesn't just directly admit that your foreign degree is equivalent to a degree in the United States. So you will need to find a third-party evaluation agency to do that evaluation for you. And the process is really quick. You will just need to do it. But usually there is no other complications or complexity related to this process.
All right, let's move on to question number 8. I think question number 7 were very similar to what we have just answered. So we move on to number 8. Does EB2 NIW requires you to have an H1B if you wanted to get that approval?
So there are actually two different categories. EB2 National Interest Waiver doesn't require you to do anything after your approval, but it is more like for a real world scenario. If your EB2 National Interest Waiver get approved, you for sure wanted to stay in the US to keep working and to keep building up your profile and build up your career. So you will need a valid status for you to keep working here. But an approved EB2 national interest waiver doesn't guarantee you, EAD doesn't guarantee a valid status to work. So you will still need to have other status for you to work here in the United States. So that could be H1B, that could be O1A, that could be CPT, any option, but it doesn't require, like H1B is not a must for EB2 national interest waiver here.
Absolutely. Let's move on. Next one. This person wanted to say, I have seen people who's been doing day one CPT for a long time, 3, 4, extra attempt for H1B, but they still haven't got it. So even if we got EB2 NIW approval, we still need to have that H1B. Is that correct?
So if you still wanted to work in the United States, you will need to have a status, and that could be H1, that could be L1. That could be any type of status that allow you to work here.
Right, absolutely. Some of the options that we just mentioned in this session, O1 visa, L1 visa, day one CPT under F1 visa, they are all of the options that you can maintain working status, but then still you have to wait for that PDs in order to file and got your EB2 NIW. So move on. What is considered sufficient qualification for EB2 NIW? Specifically into the research paper side of things, can 3 to 4 research paper or work experiences be enough? I think this definitely depends on the person. You know, if you wanted to ask these questions, you might as well, you know, do a consultation so you can provide more details. I don't think we can just judge from this simple terms. We need to understand more about you. But if the person doesn't have any patent or or some of the other rewards, some of the other obvious qualifications, what do you say would be some of the things that they might have but they don't know that will help with their NIW cases?
So patent is never necessary or a must for a national interest waiver. And I would even say research paper publication is not a must because I have helped a lot of people without any publications, without any patents to get approved. And obviously those people doesn't have a PhD degree, but you will need to demonstrate your work experience or your methodology or your work has some implication to your fields and even to the United States. And for some other evidence you can probably provide, I would say it is independent expert opinion letter because those expert opinion letter can shows that your work is benefiting this country, your work is already having some tangible results to your fields, and then just like you were saying that my work is one of a kind, my work is innovative. We need some more solid stuff for those description word. And other evidence probably people can consider will be membership or some published materials. Here we are mentioned published materials is not about publication, but like your interview and you have your own interview about your backgrounds and about your work. Something like that will usually works. And review experience, judging experience, and doing some hackathon judge, even for university, even for university level, those hackathon awards will help. Yeah.
Absolutely. Thank you so much, Trinity, for that. Let's move on. Next one, I think is a great question. Can you talk a bit more about chances on how to make a case for a non-STEM background for people that didn't come from like a traditional computer science, data science background? They're non-STEM, but what about their cases? If do you have any examples of people succeeding from a non-STEM background in terms of NIW?
So I love national interest waiver, this type of case, because it has a lot of flexibility. It has a lot of different variations. The reason why we're focused so much on STEM is because I guess most of the people here come to the United States, a large percentage is STEM students, STEM workers. But national interest waiver is never in just like the sole options for the STEM people. It can actually work for attorney. It can actually work for some people who work in, just like you said, you have a policy background and you're working for some private consulting company and your background is probably more, I mean, these type of policy, you can work on anti-money laundering, or if you're doing some policy consulting, doing some modeling to benefit the public sector. So even if you're not on STEM, you can probably still have a good chance of getting national interest waiver, but it really based on what type of project you work in the past and how is that project demonstrated your impact to the fields and to the country.
Absolutely.
Yeah.
Let's move on. I think this person was referring to our O1 part where we talk about eight criterias with O1A. This person was wondering how many of those criteria should a person fulfill in order to apply for that O1A.
So you will need to have three, but if you have a very prominent awards like Nobel Prize, then the single Nobel Prize will be enough. But if you don't have a very prominent awards and backgrounds, then three criterias.
And
Yeah.
then for those of the audience that come late, the PowerPoint was uploaded, so it's downloadable, and then also the recording will be shared to you. So definitely revisit the presentation part in case you miss anything. Let's move on. I think this person was referring to the publishing research paper for O1A as well. So would there be a part on authorship, and then also a part on research paper, or are they the same?
I think the wording here is about authorship is right. Authorship is the same as publication, but published materials is about media articles about you and your background. So it's more like, do you have an interview about you and your work? Like, and reporter just wanted to have a one-on-one interview and ask you about your work and about your backgrounds and why make you so special in your fields. And authorship is just like you said, it's publication. Yeah.
Right. Next question, we probably already mentioned that. So I wanted to move on to question number 15. Is that true that if you pay for a premium, chances of RFE will go up? Is that a truth or a myth? And then since company is unable to do it, I was planning on paying for a premium processing myself. I'm assuming that would either be an O1 or an NIW.
So for O1, O1's premium processing doesn't really enhance the chance of getting RFE, but I do see more and more premium processing cases for a national interest waiver, people without publication, people without patents. Even with patents, they have a higher chance on getting RFE. Yeah. So I would say if you are really have a strong backgrounds, you're a PhD, you have hundreds of citations, you have hundreds of publications, you will be fine using premium processing. But if you're not very confident about your backgrounds and you're not very confident about your package, probably not go with the premium process at the very beginning because you can always upgrade your case after 2 or 3 months because it allows immigration officers to have more time to read your documents. They're not like mandatory to respond to your case within 45 days whenever they receive your package. Yeah.
Right. I think we're about time. It's already 5 o'clock, so we're gonna wrap up today's sessions. We still have a couple questions we haven't answered, but we'll definitely try to do another session to answer you guys' questions. Meanwhile, I want to thank everybody for attending. I want to especially thank Trinity for come on to deliver this very informative presentation session, as well as answering so much questions. If you do want to get in touch with Trinity, I have her email down in the chat. You can also scan the QR code. We can refer you back to her. If you wanted to consult more regarding details with Day One CPT, if you scan the code, our consultants will do free consultations to you. So definitely feel free to check out. And thanks everybody for attending. Thank you, Trinity, and I'll see you soon.